So during the class, hey, so please participate. This is for you to pass. So write the question number and the answer so that I may help you should you get the answer wrong. If you get it right, yahoo, all right? So stay tuned so that we can get ready to get going with these questions tonight. So it'll be about an hour or 45 minutes to an hour. So this is Lillie Hendy coming to you with AgentPrep out of San Antonio, Texas. Okay, so let's get started with question 81. A broker has received the necessary written permission from the seller and the buyer to function as an intermediary. She has also received written permission to appoint salespersons to each of the parties. When the broker has given the proper written notice to each of the parties about who is appointed to whom, which of the following statements is true? A, an appointed salesperson may give advice and opinions to one of the parties. B, the broker may give advice and opinions to both of the parties to the transaction. Remember, we are in Texas. C, either of the appointed salespersons may give advice and opinions to either of the parties. Or D, the broker may give advice and opinions to only one of the parties to the transaction. So what is the question asked? So the broker received a written permission from seller and the buyer to function as an intermediary. So the broker is representing what both sides, right? As an intermediary. They've received permission to appoint a salesperson to each of the parties. So one realtor for the seller, one realtor for the buyer, right? Which we as agents actually attract the buyers and the sellers unless we get a lead from the company or a team leader. Otherwise, we generated those leads. And although it says they're appointed to us, it's because all contracts, all documents belong to the broker. All transactions belong to the broker. We are the associate representing the client on behalf of the broker. So take your time to read the question and answer. Type in your answer. Okay, so don't be shy. Go ahead and type your answer so that I may help you should you get it wrong. And it's okay if you do, okay? Don't be hard on yourself. All right, well, the answer for 81 is A. An appointed salesperson may give advice and opinions to one of the parties, okay? In Texas, we represent one party. We can write a transaction or a contract for a buyer. However, we will not represent them when we represent the seller. So when the broker functions as an intermediary, there is a salesperson appointed to the seller and a salesperson appointed to the buyer. And that's the only way that a broker can be an intermediary. Ooh, excuse me. Wanted to sneeze. Excuse me. And no, I'm not sick. Okay. Okay, number 82. You're going to hear a little background noise for a moment. There we go. All right, number 82. What recourse is available when a broker and a salesperson have a dispute over the commission split of on a transaction? So what recourse is available when a broker and the salesperson have a dispute over the commission split on a transaction? A, filing a joint complaint with the Texas Real Estate Commission known as TREC. B, filing individual complaints with the Texas Real Estate Commission, known as TREC. C, seeking mediation, arbitration, or civil court action. Or D, complaining to the seller's attorney. So type in your answer for 82. Remember, we take action whenever there's an agreement, process of elimination. Start out by communicating, okay, before going all the way to the top. And all the way to the top means to track. Type your answer on the chat. Anybody? No? Okay, the answer is 82C. Seeking mediation, arbitration, or civil court action. So if the broker and the salesperson cannot come to an agreement on the commission split on a transaction, then they seek mediation. And this is during a contract, a transaction, okay? Either representing a seller or a buyer. All that should be agreed upon in advance. However, sometimes there are some disputes. All right, moving right along. All right, number 83. So for those of you who just came in, we are on Texas Real Estate questions and answers, exam number 4 on this book, Texas Real Estate Sales Exam, 4th edition by Learning Express. Okay, number 83. Let me reduce the resolution there so that we can see it all on one page. Okay, there we go. Okay, at any point you have questions, go ahead and type them in the chat, and remember to type the question number and the answer in the chat. Okay, 83. A property that lies within a municipal utility district called a MUD. Know your acronyms, okay? A property that lies within a MUD, municipal utility district is under contract to be purchased by Todd and Mary Lindstrom. The contract does not include a disclosure from the sellers that reveals information about the district's bonded indebtedness or the tax rate. What is the status of this contractual agreement? A, void under the provisions of the Texas Water Code. B, unenforceable until the information is furnished. C, voidable at the option of the sellers if they are unable to obtain the required information. Or D, voided at the sole option of the buyers. So first you need to know what a MUD is, Municipal Utility District. Type your answer in the chat. Okay, nobody's typing an answer. All right, the answer is 83D. Voidable at the sole option of the buyers. Okay, so a property that lies, it's under contract to be purchased by Todd and Mary Lindstrom. The contract does not include a disclosure from the sellers that reveals information. So sellers have to disclose, anything that they know about the property or the district. And if they don't, then the buyer within a certain amount of time per the contract can void the contract. So the answer is D. The sellers cannot void the void the contract, okay, and nor can the Texas Water Code, because that's not who's in the contract with the seller. It is the buyer and the seller, right? So one of them has to make a decision, but it is the buyer. Hi, Neelam. Thank you for joining us. All right. Now, 84. A buyer defaults under the terms of an agreement using the Texas Real Estate Commission promulgated 1-4 family residential resale form. The sellers are willing to accept the earnest money as liquidated damages. Later, the sellers decide that the liquidated damages were insufficient to compensate them for their financial losses. Can the seller come back and seek additional damages, money damages? Answers: A, absolutely. B, usually. C, not according to the terms of this promulgated form. Or D, it depends on which addendum was used. So it does talk about an addendum, right? Every contract has specific performance by both parties, right? So go ahead, type your answer in the chat. Did I show the answer for 83D? And just know there is a delay between what I type and what appears at your end, maybe. Okay, Neelam says C. Anybody else? That is correct, Neelam. The answer is 84C, not according to the terms of this promulgated form. The promulgated form is the contract 1-4 family residential, and it says that liquidated damages are the earnest money. And that was agreed upon before the contract was assigned by all parties. Okay, 85. The Texas Real Estate Commission has been empowered by the Texas legislature to make rules that are binding upon the brokers and salespersons licensed by TREC, Texas Real Estate Commission. What is a rule or regulation established by the Texas Real Estate Commission known as TREC become effective? When? When does that rule or regulation become effective? Hi, Mar. Thank you for joining us. A, when appropriate standing committees of both houses of the legislature transmit statements approving it. B, when appropriate standing committees of both houses of the legislature do not transmit statements opposing adoption of it. C, when it has been approved by the governor. Or D, immediately upon publication by the Texas Real Estate Commission. Type your answer on the chat, either on YouTube or on the group or my business page, because this is being streamed to 3 different locations. Okay, Neelam says S. No, I don't think there's an S in there, Neelam, but you changed it to A. That's okay, man. I tell you what, I sometimes do that. I write answers. I'm saying one thing and I type something else. Anybody else? No, no, no. Okay, the answer is B. when appropriate standing committees of both houses of the legislature do not transmit statements opposing adoption of it. Okay, so it asked, so TREC has been empowered by the Texas legislature, okay? That's who controls TREC, the Texas legislature. And so both houses have to make a decision. However, if they don't oppose it, then it is adopted. Okay, it's not the standing committees of both houses. It's when appropriate standing committees of both houses of the legislature do not transmit statements opposing it. So then it'll be adopted. So there must be, a deadline as to when the legislature can oppose both houses of the legislature. So the first one says they have to approve it. The second one says if they don't oppose it, okay, then it's adopted. And then the third one says it's approved by the governor, and fourth by TREC. No. Okay. So let's see. So if they don't say anything against it, it goes into effect. That is correct. Okay. Number 86. An owner lists a four-bedroom home for lease with a real estate company and tells the agent not to lease it to any family with more than 2 older children. What should the agent do? Okay, so the home lists a 4-bedroom and, they're going to lease it. So in most states, you're allowed to have 2 individuals per bedroom. So that would mean you could have up to 8 individuals. Okay. However, a landlord may not want so many individuals. However, we have to follow the fair housing laws, right? So what should the agent do when the owner of a 4-bedroom home doesn't want him to lease it to families with more than 2 older children? A, refuse the listing. B, honor the request. C, ignore the request and obey the law. D, make the home available to anyone with children. So remember, we're getting paid by the principal, right? By the seller or the landlord. However, if we're being asked to do something that is not according to law, what are we to do? I just typed a whole bunch of letters by mistake. Haven't posted it though. Okay. So Neelam says C. Okay, Neelam, rethink about this. Can we ignore what the seller is telling us to do when they are the ones paying us? You work for a company and your boss tells you, hey, you need to do this. They're the ones giving you the paycheck. And all right. Yes, lots of laugh. You're correct. Refuse the listing. That's awesome. Yes. We have to obey the seller if it's according to law, but not if it's not. Okay? We refuse it. It's not worth it to lose our license because somebody wants us to do something illegal. And that would be against the fair housing laws. Okay? Number 87, moving right along. A violation of a provision of the Texas Real Estate License Act constitutes what type of legal violation? Okay, a violation of a provision of the Texas Real Estate License Act, known as TRELA, constitutes what type of legal violation? A felony, B, a Class A misdemeanor, C, a Class B misdemeanor, D, a Class C misdemeanor. Okay, Neelam says B. Anybody else? There's quite a few of you on here. I lost track of what question we're on. We're on what question? 87. Okay, yes, 87. See, I'm typing the wrong answer. All right, that is correct, Neelam. A Class A misdemeanor. So it says, although it was once a Class C misdemeanor, as a result of an action taken during the 1999 legislative session, a violation now constitutes a Class A misdemeanor subject to significantly increased fines. Very good. Number 88. Okay, and remember when, when I was taking the exam, oh my gosh, I dislike long questions, right? So sometimes I would flag them to come back to them later and keep going with all the short questions and then come back to the long ones. You want to take, no more than a minute per question. And if you can't read it quickly, then click it for review and come back to it later, read all the short ones, answer those, and then that way you have a lot more time left over. So this one is a long one. And try not to answer the first question, the answer you think is right. Read all the answers. Okay. These are some of the tips for test taking is read all the answers before choosing one, unless you absolutely. Oh, by the way, yes, happy birthday. Yes, my birthday was yesterday. Thank you, Neelam. Which of the following is the best way to extend the closing date on a contract? Okay, so we already have a contract between a buyer and a seller. How do we extend that closing date if it doesn't close within the 30 days or 45 days that it was specified on the contract? What do we use? A, change the date on the original contract and have the buyer, seller, and both agents initial. B, change the date on the original contract and have the buyer and seller initial and date the change. C, simply cross out the old date, enter the new date, and send a written notification of the change to the title company. Or D, use the Texas Real Estate Commission promulgated amendment form, fill in the appropriate blanks, and have the buyers and sellers sign. So can we scratch something out on a contract that's already been executed or not? Very good, Neelam. 88D. That wasn't so bad, huh? Okay, change the resolution here. Nope, not enough. Ooh, that one's small. Okay, 89, right? Right, we can't do that, right, Neelam? Okay, number 89. Still not on the whole page. Okay, it's almost all on one page. 150 resolution. There we go. Okay, 89. Which of the following is not, okay, a power that has been granted to the Texas Real Estate Commission, known as TREC, by the Texas legislature? A, serve as the court of first hearing for alleged violations under the provisions of TRELA, Texas Real Estate License Act. B, assess an administrative penalty, place on probation, or suspend the license of a broker who has been found guilty of dishonesty and unworthiness in his or her brokerage business. C, establish maximum amounts of percentages that may be charged for services delivered under a broker or salesperson license issued by the Texas Real Estate Commission, known as TREC. D, inspect the financial records relating to any trust of or escrow accounts managed by a broker who holds client monies for future disbursement. Years before, brokerage used to have their own escrow account, trust account, and deposit any earnest monies in there. Today, most everyone uses the title company's escrow account. So type your answer in the chat, please, either on YouTube or Facebook. Okay, Neelam says 89C. So remember, we're all independent brokers, right? So there are certain powers that TREC does not have, that have been granted by Texas legislature. So remember that the Texas legislature, okay, is the one that grants laws to TREC. Remember, both houses of the legislature have to make decisions on laws. Anybody else? No. Yes, the correct answer is C. Establish maximum amounts of percentages that may be charged for services delivered under a broker or salesperson license issued by TREC. So as real estate agents or brokers, we set the commission rate. There is no monopoly. There is no standard 6%, 5%, 10%. It's whatever we negotiate as a salesperson associate of the broker or the broker with the client. If we can negotiate a 10% commission, then we do it because the client then trusts us and knows our integrity for doing business in real estate and protecting their interests. Yes, the common is 6%, but there is no standard commission rate. Should you ever be in a group of people that are talking about, hey, let's only charge 4% or 3% so that we can get more listings, walk away from that. Okay, we cannot allow a monopoly, and that would be monopolizing it, trying to encourage. You as an individual can negotiate a 4%, a 6%. Now, some brokers will not allow you to negotiate less than 2%, because why? Brokers have to make a percentage of our commission until we cap. And what is that cap? So we have to pay a certain amount to the broker for hanging our license there, using their services, using their technology, and all the training and education that is provided, marketing and all that. Once we cap, we're at 100%, we can charge whatever commission, and we don't have to charge a commission if we don't want to. At that point, we would only pay a transaction fee to the broker for approving and reviewing all our contracts to make sure that they're in compliance. Okay, and we're not violating any laws. Okay, very good, Neelam. Number 90. And give me a moment to take a drink of water. So go ahead and read the question while I take a sip of water here. All right. 90. A seller is uncomfortable with some of the provisions written into an offer by a prospective purchaser. When should the seller consult his or her attorney? Okay, so the seller is being, it's going to be represented by a realtor, okay? But they're concerned about certain provisions in there. What should the seller do? When should the seller consult with their attorney? A, before signing the agreement. B, before signing the deed. C, before accepting any money. Or D, sometime prior to closing. Well, some of these happen after there's already a contract signed, right? So when would it be? Common sense. If you're going to buy something, somebody's going to loan you, you're going to do what before you sign? Hey, Neelam, you did another Lillie here. You did 90S. What is S? Hey, well, you get me to laugh, man. That's cool. I love to laugh. That keeps us young. All right. Sorry, my phone is a bit damaged. Aw, I totally understand. And sometimes it's operator error. So 90A, before signing the agreement, right? It says a seller is uncomfortable with some of the provisions written into an offer by a prospective purchaser. Okay, so a buyer agent or the seller is a for sale by owner, right? So they're presented with an offer. They haven't signed anything. So when should they talk to an attorney? Before signing any documents, right? Before you make a commitment to buy anything, online, or you're going to pay for something, what do? Make sure you're buying the right thing. Make sure you agree with the terms and don't do any bait and switch, okay? Read the small print. That's why we let them know you can take all agreements to an attorney, right? Because attorneys write the agreements together with brokers and one civilian. This is through TREC, right? All the promulgated contracts. So 90A, before signing any agreement. Okay, 91. Under the provisions of the typical exclusive right to sell listing agreement, a real estate agent has been authorized to do all of the following except, okay? All except, okay? A, advertise the property. B, show the property. C, tell the buyer the asking price. Or D, sign the purchase contract. So in an exclusive right to sell agreement, real estate agent has been authorized to do everything except one thing. So remember, our fiduciary duties on a right to sell listing agreement, that means whether the seller or we or another realtor procures the buyer, we get paid, right? So what is our responsibility when listing an agreement? Everything except for one. So advertise the property, show the property, tell the buyer the asking price, and sign the purchase contract. $91D is the answer. We don't sign any contracts except for execution or our name as the representative agent in association with the broker. $91D. Very good, Neelam. Okay, $92. What is the stated purpose of the Texas Real Estate Recovery Fund? What is the purpose of the Texas Real Estate Recovery Fund? A, to reimburse licensees for legal fees. B, to protect the public from monetary loss due to illegal acts of licensees. C, to permit debtors to recover property lost by foreclosure. Or D, to provide inexpensive liability coverage for brokers. Okay, Neelam says 92B. And that is correct, Neelam. To protect the public from monetary loss due to the illegal acts of licensees. That is what the recovery fund is. It is not to pay any realtor fees, E&Os, liability coverage, or loss of foreclosure. Only it's used to protect the public, okay? Because the Texas real estate laws, in anything, the contracts are to protect both sides, okay? The sellers and the buyers. Very good. '93. So anybody that just came in, this is exam number 4 in the Texas Real Estate Sales Exam book, 4th edition by Learning Express, published in 2006. And you're going to say, oh my gosh, you're using outdated information. Texas laws or state laws change. And so there are some outdated questions, but the majority are still accurate. And it's an excellent book, okay? Because it has 4 exams with 110 questions, even though today you have 125, I believe, 85 national and 40 state. So the last 30, 81 to 110 are state questions. The first 80 are national, and we are doing national state questions today. Ooh, this is a long question. This is another one that I would probably click for review and come back to it later. Okay, 93. A landlord refuses to return a security deposit to a tenant who has fulfilled the terms of the lease, returned the keys to the landlord, furnished a forwarding address, and left the premises in good condition by most people's standards. What remedy is available for the aggrieved tenant? Naughty, naughty landlord or landlady, right? So what is the remedy for the aggrieved tenant? There are landlord laws, okay? Landlord and tenant laws in every state. A, he or she may file a suit after waiting 30 days in the Justice of the Peace Court and be awarded 3 times the amount of the security deposit plus reasonable attorney fees and $100. B, she will hire an attorney and file a suit of recovery in the district court of the county in which the property is located. C, she has no recourse. Or D, she or he may file a complaint with the Justice Department. And in most areas, there are small courts that we can go to. I've had to go through this because I had apartments. So what may that tenant do when they follow everything per the lease agreement? Elam says 93A. Anybody else? Remember, this is the time to participate, write your answers, and don't be shy about participating. I will help you should you answer the question incorrect. And yes, the answer is A. The tenant may file suit after waiting 30 days in the Justice of the Peace Court and be awarded 3 times the amount of security deposit plus reasonable attorney fees and $100. So in most states, but in Texas, okay, the landlord is given 30 days in order to refund any deposit after deducting any damage that was done to the unit. And the tenant has to provide the information that was on here. Okay, number 94. What entity licenses and regulates property tax consultants? A, the Texas Real Estate Commission. B, the Texas Department of Licensing and Regulation. C, the Texas Department of Taxation and Revenue. D, the county tax assessor. So what entity licenses and regulates property tax consultants? I think once you learn who tax licenses, then you can easily answer this question. But when we don't know, then it's challenging. That's correct, Neelam. 94B, the Texas Department of Licensing and Regulation. So the answer, it says Article 8886 of the Texas Civil Statutes places jurisdiction of property tax consultants under the Texas Department of Licensing and Regulation. The county tax assessor is who assesses every property to come up with what is going to be charged as property taxes. They have a formula and a system that's really cool that they follow. Because I've helped some homeowners protest their property taxes. Okay, 95. Okay, using the Texas Real Estate Commission promulgated 1-4 family residential resale form, which of the following is not acceptable language for paragraph 11, special provisions? A, time is of the essence when interpreting the provisions of this agreement. B, buyer may do a walkthrough within the 24 hours prior to closing. C, seller will pay the appraisal as required in paragraph 12. Or D, seller will remove the playground equipment in the background prior to closing and funding. So which of the following is not acceptable language for paragraph 11, right? Special provision. There are others that are not. So which one is not acceptable language? So in other words, most of these are acceptable except for one. So Neelam says 95A, time is of the essence when interpreting the provisions of this agreement. That is correct. 95A. Time is of the essence is specified in the option period and in the contract. In the financing sections of it, it's time is of the essence for deadlines. But in the option period, right, time is of the essence. They have to do it in a certain amount of days. So buyer can do a walkthrough. Well, yes, we don't have an addendum for that. Seller will pay for the appraisal as required in paragraph 12. There is an area where it says, well, in section 12, yes. So those are expenses that the buyer, right here, that the buyer can ask for the seller to pay for their closing costs. So it would cover, the appraisal. And seller to remove the playground equipment in the background prior to closing. Yes, there is no addendum for that. So time is of the essence. Answer A is the correct one. Very good, Neelam. Okay, 96. Any questions? No, I don't see any on YouTube nor on Facebook. Okay, very good. So again, for those of you who may have just entered, this is AgentPrep for Texas Real Estate Review, we do national questions and vocabulary, but there's been more of a demand for Texas questions and answers. So that's why I'm doing more of that. Sorry, I got, there we go. I was checking to see if anybody was asking questions on YouTube and I messed up the page, but I'm back to normal. Okay, 96. A broker has a listing agreement signed by a seller and a buyer representation agreement signed by a buyer who is interested in purchasing the seller's property. Both parties have granted the broker permission to function as an intermediary through the written representation agreements, right? The representation agreements are the listing agreement and the buyer rep agreement, right? They both mention on there whether broker can be a mediary or not. The buyer tells the broker that if he is successful in acquiring this property, he plans to purchase the surrounding property also. What should the broker tell the seller about this information? So remember, what can and can the broker not do when functioning as an intermediary? A, disclose it to the seller. B, withdraw from the transaction. C, nothing. D, wait and disclose it after closing. So here it says the broker, right? And who can be an intermediary? The broker, not a buyer agent, not a listing agent. And here the broker is the one with the listing agreement and the buyer rep agreement. So they have a realtor representing the buyer and a realtor representing the seller, or the broker can also act as a salesperson. And when they do that, then they, in Texas, we can only represent one. However, the broker may have was the listing agent, and then they had a buyer and they decided they wanted to buy. We have to disclose that we can only represent one side. So either the broker withdraws from being an intermediary or from representing either party, and they both act as representing each other, or the broker says, hey, I can only represent the seller if I'm the one with the contracts. And so they withdraw the representation from the buyer agent. That would be canceled, or from the listing agent. Of course, the seller is the one paying the commission, right? So I would say it's best to keep the relationship with the seller because that was the original relationship, or assign someone else to represent the buyer. So on here, Neelam says 96C, the broker does nothing, right? A broker cannot advise, guide, or negotiate for either party when they are intermediary. I was a broker in Oregon, and in Oregon, we had dual agency. I could represent both sides. So put on the seller hat. Now we go talk to the buyer, remove the seller hat, put on the buyer hat. That's legal in Oregon. It is not in Texas. We represent one client, right? Okay. So 97. Under the canons of professional ethics and conduct for brokers and salespersons, as promulgated by the Texas Real Estate Commission, what is the primary duty of real estate agents? So under canons professional ethics and conduct for brokers and salespersons, as promulgated by TREC, what is the primary duty of real estate agents? A, to treat all parties to a transaction fairly. B, to represent the interest of their clients. C, to use prudence and caution. D, to reveal any latent defects. So what is our primary duty under the ethics and conduct for brokers? your answer in the chat. I would rethink about that. Okay, so what is our primary fiduciary duty as an agent? The answer is B, to represent the interest of our clients above and before ours. Okay, we always represent our clients first. That is our primary interest. Responsibility, old car, right? Okay, 98. There we go. Gertrude Goodhart always said that her two best friends would inherit her property when she died. 6 months ago, she died without having gotten around to writing a will. She has no living relatives. What will happen to her property? A, it will be divided between her church and the people who took care of her immediately prior to her death. Sorry about that. A, it will be divided between her church and the people who took care of her immediately prior to her death. B, since she told many people of her wishes, it will be divided equally between her two best friends. C, it will be sold to the highest bidder at a public sale conducted by the probate court. Or D, it will become the property of the state of Texas under the state's legal provisions. So Gertrude passed away, Gertrude Goodhart, intestate, right? Without a will. So within, without, intestate, within, without a will. That's how one of my students remembered it. Intestate has an in, so he said, oh, within, without. Milam says 98D. Anybody else? Or anyone else? Okay, that is correct, Neelam. It will become the property of the state of Texas under the state's legal provisions. When there isn't a will, it becomes the state legal provisions. So there was no will and there was no heirs, so it goes to the state. If they died and there wasn't a will, but there were relatives, then it goes into probate. Okay, number 99. Way to go, Manila. You're ready for your exams, I believe. Okay, 99. Any questions? Nope. All right. A seller received an offer last evening and is considering how to respond to it. While the seller is still thinking about the first offer, another offer is given to the listing agent. What should the listing agent do? A, present the second offer immediately. B, hold the second offer until the seller makes a decision about the first offer. C, call the agent who bought brought the first offer and tell him about the second offer? Or D, tell the seller that he needs to hurry up and make a decision about the offer he has in his possession? So what do we do when we get multiple offers? Or when we get any offer? And I will be cutting class at 7 o'clock as I have a Zoom coaching call immediately after this. Okay. So this is the last question for the evening. Hi, Carla. Thank you for joining and responding. And yes, the answer is A. Present the second offer immediately. So we can always go back to both realtors and ask them to write their highest and best offer, because we are dealing with multiple offers, and that's many times allows the seller to get a higher price than list price. That's what's been happening a lot in today's market. So when it's a really hot market, we advise the seller to wait a few days if they agree to get multiple offers and get higher offers than the list price. And that happens a lot. Okay, any questions before we call it a night? So remember, if you're on YouTube, or if you haven't been to YouTube, to my YouTube channel, YouTube Agent Prep, hey, I ask you to send me some love. Subscribe to my channel, click the little bell so you're the first to get an alert whenever I upload any new videos or I go live, and like the video. Write some comments. Let me help you. Please have a math calculation class. I will review that. I do have a lot of them in the past, Neelam. I noticed that not many students have been needing math, but I will take your request into consideration. Oh, okay, including amortization. Okay, I appreciate your request, and you're a faithful attendee and contributor. So of course I will take that into heavy consideration. Okay, so again, this is Wow Lillie Hendy with YouTube Agent Prep. And until next time, catch you later.